We are going to take a few minutes to just let everybody get into the webinar, get admitted, and then we'll start up. I'll be watching the numbers to make sure everybody gets in, and then we'll get started. All right, let's get going. I am delighted to be welcoming you here today to this webinar. My name is Nancy McLean, and I am a historian and board member of the Center for Media and Democracy. And I am delighted to see so much interest in this urgent topic, setting the stacked court in stone. I want to thank the host organizations, Center for Media and Democracy, Common Cause, and the American Constitution Society for convening this conversation, and thank all of you for joining us. And I can see that the numbers just keep ticking up, so that's great. If you haven't already, I see some people are starting to, but please put in the chat where you're joining us from, both geographically and organizationally, so we have a sense of who's here, which may affect responses to questions, maybe some targeted answers. But I'm really honored to have been invited to moderate today and to be in dialogue with the constitutional experts you'll be hearing from over the next hour. My research for the book Democracy in Chains led me to understand that, as I put it in the conclusion, quote, the ultimate target of the well-heeled right is the nation's most important rule book, the U.S. Constitution itself. Why, though, is altering the Constitution their endgame, their checkmate move? Because although the U.S. Constitution has more veto points than any of its counterparts, four as opposed to one, two, or three, which makes it already hugely challenging for even supermajorities to achieve very popular changes, the plutocratic donors who have brought us to the precipice of authoritarianism believe that America is too democratic. And that is why they have been organizing with growing zeal and success since 2013 for a constitutional convention to be convened as soon as 2025 if they get control of Congress. I wrote about this apocalyptic threat in the 2023 preface that updated Democracy in Chains, explaining the deep historical context of this push to alter the Constitution, the alliance that is driving this push, and how they're using capture of a majority of state legislatures to pull it off, and also what exactly the backers seek to gain from such a convention. And I concluded with this question. How can the American people deal with the prospect of such warped state governments transforming our Constitution to please fossil fuel multi-billionaires, Christian nationalists, white power vigilantes, and others who refuse to accept losing at the ballot box? That is the prime question of our time. And that is the question we will take up today, with a particular focus on how these donors and their grantees are seeking an amendment to lock in the illegitimate Federalist Society 6-3 supermajority on today's Supreme Court and to make it impossible to reform the openly partisan, grossly unethical conduct of the Roberts Six. So we have the perfect lineup to inform us about all that is at stake here, how we reach this point, and what we can do to defeat this brazen power grab. I regret that the amazing Stasha Rhodes of United for Democracy had to withdraw owing to a death in the family, but we have three other perfect panelists for this conversation. David Super, who will lead us off, is the Carmack Waterhouse Professor of Law and Economics at Georgetown Law, and one of, if not the leading legal authority on the Article 5 Constitutional Convention threat. Prior to entering the Legal Academy, David served as the general counsel for the Center on Budget and Policy Priorities and also worked for the National Health Law Program and Community Legal Services in Philadelphia. Our second panelist, Lisa Graves, is the founder and executive director of True North Research and the managing director of Court Accountability. She has served as Deputy Assistant Attorney General in the Office of Policy Development and Legal Policy at the U.S. Department of Justice under Attorneys General Janet Reno and John Ashcroft. As chief counsel for nominations for Senator Patrick Leahy on the U.S. Senate Judiciary Committee, as the senior legislative strategist for the ACLU on national security and civil liberties. She went on to lead the Center for Media and Democracy as it was alerting all of us to ALEC, the Koch network, and so much more. We are all in Lisa's debt, and we also know her to be one of the kindest people on our side of the fence. So always a pleasure to appear with her. Alex Aronson is the co-founder and executive director of Court Accountability, which is a nonpartisan research and advocacy organization working to confront judicial corruption and authoritarian abuse of power. Alex is the former chief counsel to U.S. Senator Sheldon Whitehouse of Rhode Island, who is a hero, I believe, to all court watchers, at least all those I know. Prior to that, Alex served as a chief counsel in the Senate Judiciary Committee and as an appellate attorney in the Department of Justice's Civil Rights Division. So each speaker will have 12 minutes, and then we will take up your questions, which again, you can put in the Q&A. David is going to outline for us the Constitutional Convention threat and what ALEC and the Convention of States are proposing for amendments to lock in the Supreme Court at 9 justices. Lisa will explain how the court got stacked and what it would mean if that stacking were locked into the Constitution. And Alex will close out the panel with the all-important question of what can be done to stop this. So again, as your questions arise, please put them in the Q&A. And now, David, please take it away.
Thank you very much. Thank you very much, Nancy. It's a great honor to be here, and thank you everyone for taking time to come here. Next, please. Thank you. Yeah, there are two ways to amend the U.S. Constitution. One is to have two-thirds of both chambers of Congress agree on a proposed amendment, and the other is to have a constitutional convention. We have very little we know about a constitutional convention. Next, please. Because there's very little said in the Constitution. This is basically Article 5. And there's not very much in here other than these two methods of doing it. There's nothing in here that talks about the scope, that talks about the selection of delegates, that talks about much of anything else. Next, please. How will the delegates be selected? Article 5 doesn't say. How will the votes be allocated? One person, one vote per state. Proportionate, not stated. How many votes needed? Is it simple majority, two-thirds like in Congress, something else, not stated. What kinds of changes will the convention consider? Nothing in Article 5 limits its agenda or gives Congress or anyone else the ability to do so. Will they be amending the U.S. Constitution, starting with it, or writing a whole new document? The Philadelphia Convention was supposed to amend the Articles of Confederation, but pretty quickly they tossed them in the trash and started doing something entirely different. And if the convention proposes amendments rather than a new constitution, will they be single or will they be compound? All of these and many, many other questions are left open by Article 5. Next, please. We've never held an Article 5 convention. All 27 amendments to our Constitution were proposed by Congress and ratified by the states. In the first Congress, there was a proposal to hold another convention under Article 5, and the person who led the fight against it was James Madison, a leader of the Philadelphia Convention, who knew just how unpredictable, volatile, and potentially dangerous conventions are. Consistently avoided calling an Article 5 convention ever since. There have been proposals on application for this or that, but we've never approached the two-thirds threshold. Next, please. the only precedent we would have is the Philadelphia Convention. There have been meetings of states, proponents of a convention say, oh, the states are meeting all the time. Indeed, they are, but not with the power to change our fundamental rule book, the Constitution. The mock conventions get held. I'm going to talk about one of them in a bit. But no one had any incentive to make the hard choices there because everyone knew it had no power. If you have an actual convention, all the gloves will go off and all the special interest money will go in. Um, and even when they're on their best behavior in a mock convention designed to show that these things are very safe, some pretty extreme stuff has come out. Next, please. The uh, uh, the Convention of States, one of the big advocate groups for an Article 5 convention, held a mock convention last year in Williamsburg, Virginia. They had some very, very extreme anti environmental provisions. They had some provisions that would probably gut most of our civil rights laws. And then they had this, which freezes the Supreme Court at 9 judges. So it locks in our very stacked court and precludes any statute expanding the court. And this is remarkable in part, of course, because it would be devastating to be stuck with the Robert Six indefinitely in a very unbalanced court and a very balanced polity. But it's also striking because the Convention of the States Project's Article 5 applications say it's only for 3 purposes: fiscal responsibility, term limits, and limiting federal power. Locking in the court at 9 judges is none of those 3 things. So their own mock convention is demonstrating that there will be no limits on what an Article 5 convention will do. The well-funded extreme groups that are pushing this are going to grab for everything they can and everything that their moneyed sponsors ask them to do. Next, please. The Article 5, the convention in 1787 completely disregarded ratification procedures. So some people say, well, who cares about a convention? If it comes out with bad stuff, it just won't get ratified. Well, the Philadelphia Convention, which is given great respect to this day, disregarded unambiguous ratification procedures. The Articles of Confederation said you cannot write a new constitution or amend this one unless every state and Congress agrees. And the Philadelphia Convention said, nope, it only takes 2/3 of the states, 9 of 13, to establish the new Constitution and end the Articles of Confederation. They just flat out disregarded the law and they got away with it. And there's every reason to think that a new Article 5 convention will do just that. Next, please. Um, an Article 5 convention will be profoundly undemocratic. It will not, in most states, allow voters to choose the delegates. Only in Rhode Island do voters have any role in selecting delegates at all. The other 49 states, it'll presumably be picked by the legislature and the governor with heavy involvement from moneyed special interests. The campaign and finance and lobbying laws we have are pretty obviously inadequate, but most of them won't even apply. Even bribery statutes may be unclear in this setting, and the convention delegates will be there on a one-time basis. There's no basis for not reelecting them because it's a single time that they'll be serving, and the results could end up being a feeding frenzy of the special interests. Next, please. Um, in addition, small states will demand that every state have equal votes. They already have equal votes in the ratification process, so this completely destroys one person, one vote. Wyoming and California will be of equal importance in this. The smallest 26 states have less than 18% of the US population, but would be enough to control a convention. At present, although the electorate's almost 50-50, Republicans control a substantial majority. My number there's wrong, I believe it's 29, but still a significant majority of state legislatures. Next, please. Um, the Center for Media and Democracy did research into states' laws about delegate selection. And this is who would control the state delegations. Again, this isn't going to be a popular vote. There are laws that provide that. And so the state delegations would be Republican controlled in about 29 instances, Democratic controlled in about 19, and probably split in Pennsylvania and Virginia, which means that the Republican Party would have complete control. There'd be no need for vote swapping, log rolling, anything of that kind. Next, please. Um, they could dump the existing document. The only precedent in Philadelphia did that. But if they choose to amend this, they can group things, they can log roll to improve their chances of ratification. Next, please. They can, we already have several amendments that have multiple things in them. There are about 10 different things in the 14th Amendment. There's some very disparate things in, say, the Fifth Amendment, grand juries, protecting private property, self-incrimination, due process, and in our own politics today, different people have different feelings about those things. 14th Amendment, even people are even more divided. So you could have something on guns and abortion and campaign finance that is designed to get enough people to vote for ratification, even if it made fundamental disturbing changes in some other areas. Next, please. No one has authority to limit a convention. President has no role in amending the Constitution at all. So whether it's Harris or Trump doesn't actually matter very much for these purposes. Obviously, for a lot of other purposes, it does. Nothing in Article 5 gives Congress any authority to impose rules on a convention. And if it tried, the convention could just ignore it. And there's nothing that gives Congress the authority to shut down such a convention. Nothing in Article 5 gives state legislatures any authority. Some of the pro convention groups are having states pass laws about controlling their delegates, but those are unauthorized on Article 5. There's no provision for taking away anyone's delegate status. The Supreme Court has repeatedly held, Coleman v. Miller, the leading case, that these amending the Constitution is a political question the federal courts can't get involved in. So once we have a convention, it will be beyond anyone's control. Next, please. The ratification process doesn't provide much protection here either. As noted, the Philadelphia Convention disregarded its ratification process. And if we don't ratify something immediately, it will be hanging out there waiting for a wave election. Next, please. It's very clear that if Republicans take both chambers of Congress in this election, whatever happens to the White House, they have already said that they believe they can come up with a way of counting 34 states that they think support a convention. They do this by combining completely disparate things, a balanced budget amendment here, gun control there, world governance somewhere else to get there. Next, please. Indeed, the chairman of the House Budget Committee, Representative Arrington, has already introduced legislation that would do this and calls for a convention without any limits. They keep saying, "Oh, there'll be substantive limits." No, under their proposal, there will not be substantive limits. Next, please. They will be counting all applications regardless of their purpose, which is a complete violation of the centuries-long tradition of only counting together applications for a single purpose. And indeed, hardly any of these, indeed, to my knowledge, none of these call for freezing the Supreme Court, but they'll do that anyway. Next, please. And they suggest that ratification would be by popular vote. So defeating ratification might become terribly difficult. This is a serious problem, and it could be on us in just a few months, depending on who takes control of Congress. Thank you very much.
Thank you, David. Lisa.
Yes, thank you so much, David. That was really illuminating and terrifying. I really appreciate your walking us through it. As Nancy said, my name is Lisa Graves, and I'm the Director of True North Research and the Managing Director of Court Accountability. I'm also the President of the Board for the Center for Media Democracy and want to thank Arn and Karen and Julia and the team over there at CMD for helping to put this together, along with Common Cause and ACS. And thank you all, nearly 400 of you who've come out for this webinar this afternoon. Really appreciate it. I'm going to talk a bit about how this Supreme Court has been captured, but let me just begin a little bit with just to build on what David said. We know that right-wing groups have been seeking to invoke a National Constitutional Convention, and they've been escalating that fight over the past several years in order to ostensibly mandate a balanced budget amendment, but that would open up the entire U.S. Constitution for revision, as David described. In fact, Arn and I worked at great length on helping to uncover some of this con work, and we discovered a few years ago when we were both working together at CMD that some of these con folks were soliciting money from gun groups, for example. They were raising money by raffling off AR-15s and more. They were spreading their information, particularly by targeting gun shows to gain support for their efforts. Unlike the post-colonial period or even the more recent pre-Citizens United period, the prior Constitutional Convention, the only one we've had, was not engulfed by anonymous money or dark money or corporate money. Any new con would be prime hunting ground for special interests seeking to embed their wish lists into constitutional provisions that ordinary legislation could not undo. We also know from studying this process in other countries, like in Poland, where changes were made to the judiciary that were embedded in the national constitutions, that such changes are very difficult to disgorge. Um, when I launched ALEC Exposed, one of the lesser reported components of that ALEC agenda was to send its operatives to the former Soviet states in order to help write constitutions in emerging democracies and embed anti-regulatory components in them as part of the free market fundamentalism fueled by ALEC and its funders like Charles Koch. And as Nancy McLean, our moderator, has documented, one of ALEC's main funders, billionaire Charles Koch, deployed economists to enchain democracy by rewriting Chile's constitution and other constitutions in order to embed libertarian anti-democracy tenets. And that enchaining abroad and at home became the title of Nancy's critically acclaimed book about such constitutional ambitions. Let me focus in on this other method of really trying to freeze the Constitution into place, and it's through court capture, as Senator Sheldon Whitehouse has documented in his books and speeches and questions at hearings. I am old enough to know that part of this has been underway during my entire lifetime. It doesn't have to be this way, but this is how it's been. Since I was born in 1967, actually, let's start at 1969. There have been 21 appointments to the U.S. Supreme Court. That counts William Rehnquist twice, both for his initial appointment and then to the Chief Justice position. Of those 21 appointments to the U.S. Supreme Court, 16 of them have been by Republican presidents, and only 5 of them have been from Democratic presidents. It's just been an extraordinarily lopsided process, and some of that process has been doctored in essence, as we saw when President Obama, duly elected twice as president, both winning the popular vote and electoral college vote, had his nominee to the Supreme Court blocked in an election year in order to steal that seat and put Neil Gorsuch into that role. And then we saw the reverse of that situation on the eve of the 2020 election, election day, as Americans were already voting Trump out of office, how the Republicans acted so quickly in order to install Amy Coney Barrett on the court and not allow that seat to stay open in an election year, ostensibly for the consent of the people. They didn't want the consent of the people. They wanted to lock in that 6-3 majority, that same 6-3 majority that David referenced in that slide. And as David alluded to, the U.S. Constitution doesn't set any size limit for the size of the court. Sometimes it's been smaller, sometimes it's been bigger, sometimes it's been smaller by purpose, as with leaving that vacancy when Antonin Scalia died open for more than a year. There are a number of proposals. I know Alex will talk about an array of reforms for the court, but there's nothing in the Constitution right now that limits the size of the Supreme Court. There are other limits that set limits on whether you can serve if you're acting under good behavior or not, that I think need to be further explored. But in terms of court capture, it's sort of almost a miracle that after 16 Republican appointments compared to 5 appointments by Democratic presidents, it took until the Trump appointees to really secure this sort of mega super faction, basically, that is not tied to precedent, not willing to really be bound by the legal precedents, including the Dobbs decision to reverse Roe. But really, that issue, and I'm going to go into sort of how we got here. That issue actually began much earlier than Trump. The fact is that there was a concerted effort to try to push back on the U.S. Supreme Court after Brown versus Board of Education. So a number of people will trace the current court capture efforts to Roe versus Wade and this effort to try to reverse Roe and the way that the right wing sort of brought together these anti-abortion forces with the help of Phyllis Schlafly and others. But in fact, this movement to capture the court is rooted in racism. It's rooted in hostility to Brown v. Board of Education. It's rooted in sort of the forefather of, in fact, the exact forefather of Charles Koch, his father, Fred Koch, in attacking the U.S. Supreme Court. And that attack was also joined by Richard Nixon when he was running on his law and order platform, saying that he was going to basically put people who are law and order, so-called law and order judges on the court. Then Reagan ran and expressly on a platform that was anti-abortion, that there would be a litmus test for people to get on the court. Now, some of the judges who were appointed, like O'Connor, took her role as a judge, seriously, not to impose her personal views or other people's personal views, but to follow the precedents that the court inherited. And the notion was that it was illegitimate for a court just to change positions because of membership change that would make the court basically into just a political operation and not respect the court as an independent institution that is supposed to decide cases fairly. Now, to be fair, for the bulk of American history, the Supreme Court has not been on the side of the people, really, until that Warren Court read the Equal Protection Clause of the Fourth Amendment to mean what it said. The court had been content for decades to suppress the rights of African Americans in the United States, to not let the 13th, 14th, and 15th Amendments really mean what they say, and also to make other irrational rulings. And I won't get into all of them. I'm happy to on Q&A if you want. But the fact is that we only had a very brief period in U.S. history where the court was actually, in my view, reading the Constitution to secure the freedoms that people were promised in the Constitution. But those Reagan appointments, they weren't enough for them to accomplish this revolution, not just in terms of attacking efforts to address the structural racism that is definitively part of American history, but also to attack the expansion of freedoms. What is this notion of freedom? What is freedom if you can't marry the person you love? What is freedom if you can't decide when and how to have children or have access to birth control? There are all these questions that are important questions and ones in which we, in essence, have given the courts in some ways too much power. And Alex, I think, will probably speak to this because, in fact, we're going to have to secure these rights ourselves. We have to reject this court and this court's actions. But what really happened historically is you had this combination of this sort of racist reaction to Brown v. Board. You had these corporatists come in with the Powell Memo in 1971, which talked about the neglected opportunity at the courts. You had the rise, and by the way, Charles Koch said that Powell's memo did not go far enough. But then you had the rise of the Federal Society, which was created in 1982 specifically to be advance so-called conservative and libertarian agenda. At that time, the libertarian agenda was almost entirely funded by Charles Koch. That Federal Society had its ambitions at creating the staffing, a pipeline for power for right-wing operatives to get them into positions of power. And in the 80s, they predicted that by the 90s, they would have people in positions of power. Of course, they already did. Antonin Scalia was one of the early advisors of the Federal Society, became a judge, became a Supreme Court justice, and more. But that movement still did not achieve its aims, in part because some of the people who were nominated were actually acting as impartial judges, like David Souter. David Souter was nominated by George Herbert Walker Bush. He was an appointee to the New Hampshire Supreme Court. On the bench, he actually followed legal precedents and I think acted as a fair judge. And so what happened? The right-wing movement was enraged. They pushed forward an effort called No More Souters. No more suitors. They didn't want to have any more chances to take with the Supreme Court. They wanted to make sure that they got people who were ringers, who would deliver what they want. And so you'll notice back in 2005 when John Roberts was nominated, there was no concern that he was going to be another suitor. Leo vouched for him. Big money came in to help ensure that he was moved on to the Supreme Court. And then when the next nominee came up, Harriet Miers, she was canceled because they didn't believe that she was a sure enough vote for them. And Alito was swapped in her place. Again, no more suitors was not the refrain against Alito. So fast forward, right after that, you had the Supreme Court revisiting abortion precedents. You had the Supreme Court changing more than a century of law on gun rights to limit the ability of the cities of Chicago and DC to regulate handguns. You had the 2010 decision in Citizens United to basically rewrite the First Amendment in order to give C4 groups, a certain type of nonprofit group and others, the power to spend unlimited secret money to influence our elections. Then you had the attack on the Voting Rights Act by John Roberts to really limit the enforceability of key provisions of the Voting Rights Act that were won by literal blood and sweat and tears to enforce the 14th and 15th Amendments. Then you had the Roberts Court again intervening on maps to make it more difficult to have truly representative democracy by making these very distorted, these very gerrymandered maps allowed. And even in this last Supreme Court term, allowing a racially gerrymandered district, one in which the Black population was largely bleached out of a district in South Carolina to stand because the purpose was supposedly political, not racist, not based on race. And there are other instances in which this Supreme Court has put its thumb on the scale of justice and in our elections, including its willingness to allow the Alabama maps to stand in place during the 2022 midterms, even though those were invalid maps, but to allow them to stand to give the Republican Congress, to basically create a Republican Congress by a narrow majority. And now we've had the most recent set of examples from this Supreme Court of its intervention on the side of the party that appointed it in the trio of cases this term, which include the Colorado case where the Supreme Court acted super quickly in order to make sure that Trump stayed on the ballot despite the express ban of the 14th Amendment, a ban that by the express terms of the Constitution can only be removed by a supermajority of Congress for people who are engaged in insurrection. You had this intervention in the January 6th criminal prosecutions to change the rules to limit the ability to prosecute the people who were involved in the violent insurrection on January 6th. And then, of course, you had the Trump immunity case, which created unprecedented, reckless, dangerous criminal immunity from criminal prosecution for a president of the United States, despite the express command of the Constitution that the president's duty is to faithfully execute the laws, and the express command of the Constitution that, in fact, a president can be impeached for high crimes, for conviction, or for high crimes and misdemeanors. And so you have a court that, in my view, is out of control, and one that is in need of substantial reform. Now, I'll conclude just with two quick thoughts. One is I hope you didn't miss the news this past month that Jenny Thomas was texting to one of the groups that has litigation before the court. That group is First Liberty, and that Kelly Shackelford in the news story reported by ProPublica spoke out Jenny's words about how appreciative she was of their efforts to stop court reform, and in fact how their efforts to stop court reform was putting wind in the sail of judges. The second thing I'll say is that it just cannot be underestimated how much money has already been spent in order to try to capture the U.S. Supreme Court. At True North, we tallied more than $600 million that Leonard Leo had at his disposal through the groups that he's closely tied to in order to capture the U.S. Supreme Court, lower federal courts, and state Supreme Courts. That was before we learned, again through ProPublica, that the Supreme Court advisor to Donald Trump, the person who chose the people Donald Trump chose the Supreme Court, that he had been given control of a $1.6 billion trust fund, the Marble Freedom Trust. To this date, as of now, we can tally that Leonard Leo has had access to nearly $2 billion over the last nearly 10 years to advance his court capture agenda. This is a significant amount of money that has really led to this capture of the U.S. Supreme Court. And it has also helped create a culture of, in my view, corruption, where you have justices like Clarence Thomas being introduced to matchmaking, as Dahlia Lithwick put it, where Leonard Leo is marrying up some of these Supreme Court justices with billionaires or being even their travel agent in a way in the case of Sam Alito's trips with Paul Singer, underwritten by another billionaire who we've written out about on our site. But the fact is that we have a court that is engulfed in a cloud of corruption, and that is actively using the power of the court in order to act a partisan political agenda to limit and restrict our freedoms. So with that, I will conclude and pass the baton back to Nancy and Alex.
Go, Alex.
Thanks so much, Nancy. And Lisa, it's an honor to be here with you today. My name's Alex Aronson, a co-founder and executive director of Court Accountability. And I'm really honored to step into the very big shoes of my friend Stasha Rhodes, who leads an incredible new coalition that launched last year called United for Democracy, which has brought together over 150 national and state-based groups to work together to build a new politics around this threat and to really push Congress to confront it. Lisa mentioned, some really important kind of underlying dynamics here around power, and that really sort of explain the moment we're in that Professor Super so helpfully articulated around the Constitutional Convention threat and the effort to lock in a nine-justice Supreme Court majority, which is happening now and is really coming to fruition now, by no coincidence of timing, right? It was after the outsourcing of judicial selection to this dark money operator, Leonard Leo, under the Trump administration, these Machiavellian maneuvers that Mitch McConnell and his Senate Republican allies pulled off to really hijack these seats on the Supreme Court, put their allies in power there. They've got a durably entrenched Supreme Court supermajority now, by virtue of the very unfortunately time passing of a hero to all of us, I'm sure, Ruth Bader Ginsburg at the end of Trump's term, the reversal of the Garland principle that voters should have a say in the selection of a Supreme Court justice in an election year on a much shorter timeline, right? People were already voting when they confirmed Amy Coney Barrett. I was in the room. We were in the middle of a COVID crisis. I was double masked and wearing a face shield as they were jamming her through to secure that critical fifth vote to overrule Roe versus Wade, which of course was such a huge priority of Leonard Leo and the theocratic Christian nationalist element that has become such a powerful force on the right, in alliance with these corporate billionaires that have, since the 70s and the Powell memo, really been invested in this judicial capture strategy. Nancy mentioned I spent time working in the Senate. I just mentioned I was there in the Barrett confirmation. That really gave me an interesting perch to see how these power politics were developing. I was sitting behind Senator Whitehouse, who sort of uniquely on the Senate Judiciary Committee could see how this threat was mounting. He actually came to this work, the oversight of dark money, from his work as a real champion for climate justice and combating climate denial. And he noticed it was the same fossil fuel dark money billionaires that were flooding the judicial capture operation that Leonard Leo was running, as were active in climate denial. But meanwhile, the Senate Democrats, even as judicial selection was outsourced to these extremists who were nominating and confirming a whole new breed of judges, right? This was the manifestation, the real bringing to fruition of what Lisa was talking about, with the no more suitors strategy. These were movement zealots, people like Matthew Kacsmaryk, who had spent their whole careers as warriors for these various ideological interests. And the Democrats that I was working in such close proximity to, they didn't really have a strategy to confront it. Meanwhile, the media was covering it sort of as more of the same. Sure, it was heightened, tensions around partisan politics there, but they didn't sort of dig into the courts and the sort of rampant corruption and scandal that we are now learning about, thanks to the work of Center for Media and Democracy, Lisa's tremendous research, the great investigative reporting that we've seen from folks like Jane Mayer and Nancy's, incredible book and constant work, and ProPublica, of course. And then, I think, frankly, there's a large judicial advocacy landscape on the left that has long sort of created a mythology of the courts as a place where we should go for rights and freedoms. Lisa touched on this also. Because we've never really had a proper democracy in this country. And during this critical window in the 20th century, the courts were such an important place to secure rights and freedoms against mostly state-driven attacks on minority communities, on the vulnerable. But sort of what we think sort of happened was that that mythology that progressives created around a living constitutionalist vision of the Constitution, really created a lot of goodwill and insulated the courts from the type of public scrutiny that we think they merit as an incredibly important branch of government. And over the years, particularly as Republicans rigged the confirmation game to get more and more of their justices on the court, we had the incremental devolution of rights and freedoms under the Rehnquist Court and the early Roberts Court. What we've witnessed is the real aggrandizement of judicial power, mostly at the expense of Congress, at the expense of the people's most direct democratic representatives in the federal government. And Congress just really hasn't had the answers. And, I think for a long time, because of these investments in Republican judicial politics, because of the creation and the fomenting of the religious right around that priority of overturning Roe versus Wade, this was, as a political issue, this was something Democrats were sort of reluctant to touch. They didn't see it as a winner. They didn't want to talk about it, just like abortion, right? Democrats didn't want to campaign on abortion. Now that these vital freedoms have been taken away, it's deeply unpopular what the court's doing. This is why it's been outsourced to the unaccountable, unelected judges to advance this toxic agenda. And I think the same thing's happening with the court. The switch is really flipping, and we've got an opportunity here. I saw one question in the comments about how do we get people engaged in this? People are starting to really engage. When people, the court is not necessarily the first thing people are thinking about when they're thinking about, for example, casting their ballots. But when you remind them that the court is at stake and the replacement of up to 3, 4 justices is at stake this fall, it becomes an urgent priority for them. And you're starting to see a lot more mobilization and support as reflected in Stasha's coalition, United for Democracy, from issue groups, from multi-member, million member groups around the country whose constituencies recognize that our progress is going to be inhibited until we do something about this threat. And so as a result of that, I think we're starting to see some really tremendous progress towards reform. And we're seeing it in a couple of different landscapes. Some of it is sort of low-hanging fruit, stuff that used to be really bipartisan, stuff that even when I was in the Senate working, during the Trump era, we could find some bipartisan agreement on basic ethics principles, disclosure. That bipartisan support is going away because the Republican Party has realized the extent to which the court is, again, doing its dirty work. But, for example, Representative Raskin, and Representative Ocasio-Cortez have a very simple, straightforward gift ban to prohibit justices from receiving these types of extravagant gifts, to apply the same gift ban that they themselves abide by as members of Congress. That bill polls at 90% in swing districts overall. So Republicans, independents alike are outraged by this corruption and want to see reform here. There are comprehensive ethics packages like my former boss, Senator Whitehouse, is advancing, the Supreme Court Ethics Recusal Transparency Act, which has a really a good enforceable ethics regime, and that it really applies strong recusal standards. We've seen the courts and these justices' unwillingness to abide by basic recusal standards and laws. Alito, Thomas have very clear conflicts of interest. The appearance of partiality in these cases currently under current federal law requires their disqualification and recusal from some of these cases, and they're refusing to. So some of these bills just, provide enforcement mechanisms that would make that effective. I don't think we should kid ourselves that those types of reforms are going to be nearly enough to constrain what is now, a court majority that has weaponized itself against democracy, as we're seeing in cases like Dobbs and in, most recently Loper Bright, the attack on the administrative state, and the Trump immunity case, which completely takes the knees out of fundamental notions of separation of powers. There's a lot of bipartisan support and momentum around term limits. There are some constitutional questions. The good behavior clause arguably protects life tenure of these justices, which of course insulates them from accountability when they behave really badly because of the breakdown of our political process. Even Trump could not be impeached and convicted for, leading a violent insurrection and an attempt to steal the election. Um, but but there's also really strong constitutional arguments for the types of term limits reforms that we're seeing. For example, by placing judges in senior status, which the court itself has said is consistent with the good behavior clause. There's two versions of that on offer right now. There's one that it would be prospective, another that we tend to favor, which would be retroactive and apply retroactively to justices like Thomas, who have now been on the bench for many decades. We're also starting to see some really promising advancements to rebalance the power that is so out of kilter as the court has, increasingly aggrandized its own power at the expense of the People's Congress. One example, which has a surprising amount of support in the Democratic-led Senate, is the No Kings Act, which responds directly to the Trump immunity decision, declares the Trump immunity decision wrong as a matter of constitutional law. The Congress has a role to play here too. I think we've become too enamored of what the right, largely the right, has sort of turned into a grotesque distortion of this idea of judicial supremacy that Marbury versus Madison sort of established. Marbury versus Madison, this foundational judicial review case, it really established judicial review. It did not intend to place the court as the sole arbiter of constitutional meaning and policymaking in our country, which is what it has grown into. And the No Kings Act not only, rejects that determination that the court made this year, it also strips its jurisdiction using pretty clear constitutional authority in Article 3 of the Constitution under the Exceptions Clause. Most people don't know this, but it's a commonly used tool. The court's appellate docket, which is 99% of its docket, is subject to the exceptions and regulations that Congress shall make. And the Congress uses this in less freighted contexts. It uses it. They used it to protect Joe Manchin's Mountain Valley Pipeline. They took away the court's ability to review that pipeline deal, and the courts so far have respected that. And so that's what it's done here in terms of challenges to the constitutionality of that law. And it channels jurisdiction to the DC Circuit to take it out of the Supreme Court's hands. And then yesterday, I don't think I have time to get into the details of it, but a very exciting bill that we're still reviewing called the Judicial Modernization and Transparency Act that Senator Wyden, who's been a really diligent overseer of the tax abuses by Thomas and Harlan Crow, adds 6 justices to the court over staggered terms, establishes a new supermajority threshold to overturn acts of Congress. This is the type of, I think, action we need from Congress to start, really flexing these constitutional muscles that it has let atrophy over these years. I'm sorry, I think I might have gone over a little bit, but check out that bill. I think there's a lot in there, and we move this forward by building movement power and driving politics, connecting it to our issues, refusing to say no when we pass advancements like row codification or voting rights protections, which the court will strike down because that's what they're there for. We can't just pass that stuff. We have to have a plan to protect it and secure our democracy along the way.
Thank you. Thank you to David and Lisa and Alex. These were incredibly rich, well-prepared, incredibly informative and alarming and somewhat reassuring in the last case presentations. Our Q&A is abuzz with questions, and we have 11 minutes left. So the first thing I want to answer came up from a number of people who are asking whether this recording would be available. And the answer is yes. It will be sent out to you after this. And I think what we will do too, I'm going to ask, particularly Alex, if you could maybe bullet something, to send out with that so that people can watch some of the reform efforts that you've been talking about. I would also like to suggest to our sponsoring organizations that we have another webinar. I don't know if it's the same people or other people, but to follow up on this much larger question of what do we do about this court that's absolutely out of control and is out Alex said, is now weaponized against democracy in different ways. That's running through all the questions here. But I would say, and there are some technical questions too. But one thing I want to get to, and that we none of the panelists have spoken to, is this question of court expansion. And I do want to say to Randy Jones, who first posed it as the first question, this question of court expansion, as a historian, we need to make a pact on the progressive side to never say packing the court. That was actually the phrase that those who opposed Roosevelt's effort to expand the court used. And it was a terrible political defeat for him because there was so much opposition to the idea. So packing is definitely not the word we want to go out with. But because it is a fraught topic, but I think something that is a more surgical expansion is a really good idea and is necessary. And I just want to draw the attention of panelists to, I believe it was Carolyn Taylor, who spoke of a more narrowly tailored approach to expansion that kind of took into account the stolen seats. So she said, in my comment and link above, what do guests say about the following? Senator Markey and White House have framed expansion proposals to 13 justices with reference to the two Mitch stolen seats, et cetera. So it's kind of a tit for tat thing. And Alex, you're probably best placed to address that. But could you speak to this larger question of court expansion and how realistic you think that is? You know, because some people are saying, do you even believe ethics reform will happen? But maybe take on that question about expansion and how we should talk about it and how realistic it is.
Sure. Sorry, I just got frozen here. One second. So, I think expansion, I think many folks are right to think that it's probably what's necessary here.
Mhm.
I do actually think there's a lot of power in some of these less sort of structural reforms that simply using the tools right there in the Constitution, like the exceptions clause, which of course would produce big, fights
Mhm.
and the court would strike stuff down. And I think that's sort of the ultimate thing. Even though we have a very clear constitutional history that the Congress can shape the size of the courts, I think this court majority would figure out a way to strike down an expansion bill also. I do
Yeah.
agree with Carolyn that sort of there's one concern with many of the expansion proposals out there that it sort of just looks like sour grapes, that it's perceived as a power grab. This stuff doesn't poll very well. I think, frankly, the Democrats in Congress operate too transactionally, too much based on polls to take that up. I think they're still reluctant here. They haven't been using these muscles. And so, Wyden's bill actually does do this, right? It expands the number of justices to 15. It expands the number of circuits to 15. And it staggers the appointment to be every president would get an appointment in the first and third year of the presidency. So I think that does a lot to insulate it from charges of it being a power grab. But I think a lot of work actually is necessary and political work and movement building work before we have a Congress that will be willing to do this. And to the concern that we wouldn't even be able to pass the low-hanging fruit, I think that's a fair concern, right? As long as the filibuster remains, that we know that the Republicans aren't going to play ball on this. And so, it's going to have to, just like Harris recognizes that securing protections for reproductive freedoms is going to require breaking through the filibuster. So too will any of these reforms we're talking.
Yeah. There were also some questions about the role of the Federalist Society in this, whether it was kind of, I believe the word that the questioner asked was a shadow pillar to what we're seeing here, and also about the relationship between Project 2025, which I think, progressive people have done a really good job of alerting a large section of the American public to. So I'm not sure exactly who would be best for that question. I'm guessing maybe Lisa, it's you, but David, if you want to pitch in on the Federalist Society or the connection to Project 2025, which a lot of people are already talking about, please do.
I would just say that Leonard Leo stepped back from his day job after it was revealed that he had become extremely rich as he was helping to get Brett Kavanaugh and other justices on the Supreme
Yeah.
Court. But he's still the co-chair of the Federal Society. And he has over time used that structure, the Federal Society, for example, at the state court level, to try to change the rules for who gets to become a judge at the state court level in order to eliminate merit selection. Because you don't need merit selection if you have your own personal selection process. So he continues to play a significant role and obviously has a lot of money at his disposal to do so. And I guess I would just add just quickly on the question of Project 2025, as Alex and I and others have talked about, the fact is that the Supreme Court has already helped advance many of the goals of the Federal Society, the goals of Leonard Leo, goals of Project 2025, and a number of the groups that are credited in Project 2025 have been funded by Leonard Leo and this network. But the court has been moving forward with that dereg agenda, the agenda that really Charles Koch has helped underwrite through funding the Federal Society, through working with Leo on court capture and more, and has done so in a series of cases, West Virginia versus EPA, a trio of significant cases this year, including the reversal of Chevron and more. And there's obviously other parts of Project 2025 that relate to reproductive freedoms and other rights that are, under attack by Project 2025 that you can check out on one of our websites, which is project2025admin.com. And I'll step back and let David respond if he'd like to. All right.
Okay. So again, there are so many questions in the Q&A, but our time is limited. And so I also want to go to something hugely important that a few people ask in different ways. And one person said, Nachiket said, how do we get apathetic people to care about this? And someone else said, like, what can an ordinary person do? And I will say, as a historian, the Supreme Court really depends on its legitimacy. And when it gets too far out of step from the people and what they think, it begins to have problems. And we saw that historically, in a number of different times and ways. So I think it's incredibly important that ordinary people be paying attention to this and that they find ways to make their views heard and effective. But I would love to hear around from our panelists about, what is the way to get ordinary people to care about this? Because also, we've heard that even with democracy under threat, so many people are so overwhelmed with their lives. They're like, well, what's democracy? I don't know. What about the heating bill? I don't have health insurance and democracy isn't working for me. So what does it take to convince people that all that we're talking about is going to have huge impacts on their lives? So do you three have thoughts to share with our viewers about kind of how to take this home to their organizations and communities and people that they're in conversation with, about the incredibly high stakes of what you've been describing?
David, did you want to go first?
Sure. I mean, I think a lot of this comes down to making it very concrete. Democracy is important, our Constitution is important, but as you say, some people's daily lives make that seem abstract.
Yeah.
But this is about real issues. This is about giving the extractive industries the ability to completely gut our environment.
Yeah.
That's what one of the constitutional amendments, the Convention of States is pushing would do. This is about getting rid of consumer protection laws. So all those exploding cars that we had in the 60s and 70s can come back without any constitutional authority for the federal government to regulate it. Do you really want exploding cars? This is about vast expansions of the government over women's control over their bodies. Is that okay with you? I think pointing out that this is not someone's seminar topic, but there's a real program here, an aggressive program, and controlling the Supreme Court and rewriting the Constitution is the way to move that forward.
Alex, do you want to have the last word, or me? Do you want me to go next? How do you want to go?
You go ahead, Lisa. You got it.
Okay, I'll defer to you to go next, but and Nancy, but I would say we've never had the type of reform impetus for reform that we've seen in this last couple of years. The investigative work by, reporters and our team and others has really opened people's eyes, and people get it. This court is out of control and it is operating under a cloud of corruption. And obviously the Supreme Court's decisions have been so radical, so reactionary, so regressive that they have woken up a whole generation or generations of voters to what's at stake. And so I would say I have tremendous optimism about the fact that more and more people care, more and more people get it and understand that we cannot allow this court to continue without reform. And there are a number of common sense reforms that could be pursued very quickly. And so, but do we need to do more public education about what's at stake, what's happening, what the risks are of a constitutional convention, what the risks are of letting this court continue unconstrained in destroying our freedoms? Yes, we definitely do. And I'll pass the baton to my dear friend Alex.
I don't have too much to add to those two really excellent answers. One thing I'll say in terms of that public education element is that we've had a lot of conversations about reforms and policy questions, a lot of which is sort of, a little bit out of reach right now, given, political context. I think a pro-democracy House of Representatives majority is, very likely next year and would have significant oversight capacity to get to the bottom of a lot of this stuff. I think the impulse to have the January 6th committee, pursue the public education and investigative agenda that it did, really changed public understanding of what happened that day. And we think of this very much as the flip side of the violent insurrection January 6th coin. This is a prestige Federalist Society billionaire coup on American democracy. And there's a story to tell there, and there's a lot more to find out. We know there is. And the Congress should be doing it. And so, get involved with organizations that work on this stuff. Check out the United for Democracy website and see if there's a state and local groups. Check out our website at Court Accountability and reach out to us. We can get you plugged in. We're gonna, we work closely with Congress. We want to help them do their job better, but we also need to put pressure on them, and we're willing to do it. And they're not gonna do it unless they hear from us. That's, I think, the main thing.
Thank you. This has been incredible. I want to say there are a few more questions of people who are really concerned about where this is all going. One person wrote, it said, what happens when after the Constitutional Convention, when people realize that their rights and freedoms have been taken from them? Another person says, how is this not going to lead to a hot civil war? And another person says, by the time people pay attention, it will be too late for people to do anything! Exclamation point. That's my fear! Exclamation point. So this is really urgent stuff. This is really serious. I'm here saying, and I'm sure they'll be willing to do that our co-sponsors have a follow-up to focus on all these questions, to call out the many particulars that have come in the Q&A, and to allow that, but also maybe to provide some training for ordinary citizens like those, who are writing into the Q&A saying, what can I do? How can I jumpstart this conversation in my community? And I think just as people on the, sort of, I don't know, sane to very progressive spectrum, that pro-democracy perspective, have done an excellent job of alerting the citizenry to Project 2025. We could also do something else like that about the court, right? And have people ready, have discussions going on in communities, have panels, maybe there's documentaries, etc. But it is clear that there is huge interest in this topic and in hearing more from great folks like you who are in the trenches about how we change all this. So we will have to close it out. So we respect your time. We had said it would be an hour, but we will be following up with sending out the video, and we will be following up with other ways to help you talk about this in your communities, and also to have your questions answered about what we need to do to reclaim the Supreme Court from this illegitimate 6-3 billionaire bought majority that is wreaking so much havoc. So thank you all for coming. Thank you to our amazing speakers, David Super, Lisa Graves, and Alex Aronson. It's just such an honor and a pleasure and a bodily challenge to spend an hour with you. But I think we all feel better that knowing that people like you are on the case, and that the good people who have been commenting in the chat and the Q&A are following these issues so closely. So thank you all. And on behalf of the sponsoring organizations, go forth. And yes, we have a lot of work to do over the next several months, and we really need to roll up our sleeves. All right. I think I've concluded this about 6 ways, but this one's the real one. Goodbye.
Thank you, Nancy.
Bye, everyone.